Okay. So the second question we're gonna be dealing with obviously Nick, and it goes as follows: if we sign a fixed term lease with two natural persons, right, and we add a clause that says that the lease can be cancelled by any party with two calendar months notice. From my understanding, the writer says this cannot override the CPA. So the tenants will still be able to give 20 business days notice, but the owners, the writer says, will be able to cancel at any time with 2 months notice also. Or the question comes in, can the tenants decide then, Nick, to forego their right to the 20 business days by signing for such a clause? Nick?
Perfect, thank you. So this is one of the examples where we have to deal with multiple areas of legislation that affect singular agreements, okay? And part of our job, as lawyers, is we have to reconcile ourselves to how these different legislations play together. So there are two pieces of legislation that have been alluded to in this particular question, and the writer is very knowledgeable, clearly, about what legislation they're playing with. The first is obviously Section 14 of the Consumer Protection Act, dealing with fixed term agreements and the cancellation of fixed term agreements. Okay. And as we know, Section 14 places certain restrictions on a supplier of a good, i.e., the landlord in the circumstances, to cancel the agreement. And that is the 20 business days notice. Okay. Now, that is one element of this question. The other element is, in terms of the Rental Housing Act, the Rental Housing Act Section 45C reads as follows: that the landlord has rights against the tenants include their right to terminate the lease in respect of a rental housing property on the grounds that do not constitute an unfair practice and are specified within the lease. Okay, so the Rental Housing Act has an acknowledgement that the parties can come to an agreement for the termination of the lease agreement, okay, provided that they are in the lease agreement. So, number one, you must understand that when that is said there, that's got to be in writing. This can't be a verbal, implied sort of lease. It's got to be in writing, specified in the lease agreement, and it cannot be an unfair practice. Okay. And remember, when we talk about unfair practices, this is something that the court or the legislature leaves open for the courts to interpret. So when we're playing with unfair practices, we've got inklings of what they look like because of old case law, because of regulations that have been brought out, but those are not exhaustive. So you need to be careful with what constitutes an unfair practice. The way I rectify myself with these two pieces of legislation, because it can be confusing and you sort of say, well, how do we deal with this? Are we supposed to do 20 business days? Can we agree to anything else? Okay. Section 14 of the Consumer Protection Act specifically deals with cases of breach of the agreement. Okay. And the intention behind the legislature with Section 14 is to provide some breathing room for a consumer of a good, okay, or a service to rectify that breach and to receive proper notice of the breach of the agreement. Okay, that is what the legislature is doing. They are saying, before you cancel a fixed term agreement, an agreement that's intended to go for a long period of time, you've got to give 20 business days notice. That is the requirement placed on the landlord in the circumstances. Okay, but that requirement is only there in the event that there is a breach of the agreement. I read this as different from Section 45C. So 45C, I'll give you an example of what a clause there might look like. Let's say that it's agreed upon between the parties that in the event that the landlord needs to move into the property, okay, to live there, they agree in the lease agreement that the landlord can then give notice, a 2 months notice to the tenant to move out. I don't see a problem with those two clauses both simultaneously existing in the same agreement. You can't use the 45C clause in the event of breach, but it's not intended for a breach. You can see there that the intention is, well, there's a different circumstance that the parties are recording in the agreement, and then it's absolutely fine. So as to the question that we've been asked, can you include such a clause into your agreement? I don't see a problem with it. It's luckily what they've indicated they want to do is give a 2 months notice. So what is important about that is if you have less than a month, okay, you might run into a problem, because if, say, for instance, your tenant has breached the agreement and you have another clause that says, well, I can give a week at any point during the lease agreement, you might fall foul of the legislation. And remember, you can't contract out of the legislation. You, as the landlord, you have to follow this particular provision if you fall within the definition of a fixed term lease agreement within the CPA. So because they've given 2 months in terms of this clause, I don't see a problem. I think it's a perfectly valid clause that can be added into the particular lease agreement. Okay. In the event that there's a breach of the agreement, I still maintain you're going to fall within the ambit of the Consumer Protection Act. So yes, you're going to have these two clauses that are in the lease agreement, and they're going to look like they conflict one another. Okay, but if there's a breach, you're still going to have to follow the provisions of Section 14. The reliance there is on the tenant to say, well, no, he's not actually given me the breach in terms of the legislation that I am entitled, and he's using this particular provision that we've agreed to outside of a breach situation to try and wrap up the lease agreement at the end of the day. But as for can you have both of these terms in a lease agreement? Yes, they will just be applied in different circumstances. And that's why I'd be very careful about what conditions you place on this 2 months notice. So for instance, I've given you the example of a landlord is moving into the premises in the circumstances. There's nothing to say that the parties can't agree to just 2 months notice at any point. That is the agreement, and it doesn't seem to my interpretation to be an unfair clause. However, I would be cautious about how you put that clause in and under what circumstances you can actually use it. Maybe have a bit more specificity on that particular thing, so it's not open to abuse by either party in the circumstances.
Absolutely. So yeah, thank you very much. Obviously highlighting the importance of the regulations and the acts, and obviously enforceability and application of either or both of them at any given time in the agreements that tenants and landlords enter into. And yeah, so that does bring us to the end of today's 2 questions and answers. Thank you, gentlemen, once again for sharing your expertise with us, and we'll see everybody again next week. Thank you.
Perfect. Thanks, guys. Cheers.